One of the key steps to offering testamentary trust is having a quality and reliable precedent that you can trust. So, I want to tell you what I think is the gold standard in a testamentary trust. And you can either use this as a benchmark for your existing precedent to have a look at it, or if you are looking at other precedents and upgrading yours, this is what I think you should be looking for. Number one, plain English. Easy for the client and their advisors to understand. It's going to make your life so much easier if the client can look at the document and get their head around it, not feel overwhelmed or scared. I feel like with testamentary trust, as soon as the clients go, this is really complex, this is confusing, they kind of just switch off and back out of the process, and it can really undermine the ease of the process. So if the client can understand the will and you've done a really good job preparing them and explaining how the trust will work and how it's beneficial to their family, then it's going to make everything so much easier. So plain English is the way to go. And I'll just say, in terms of your mindset as well, if you can understand the will and know with confidence that you can work out every clause in the will and what it means, and the client's not going to ask you something and you don't know it and you'll feel caught out, that's going to make your process of offering testamentary trust much easier as well, because you're not going to get in your own way and kind of feel a bit reluctant or sheepish. Like, leave the imposter syndrome at the door, and plain English can really help with that. Foreign persons is becoming a really big thing. So especially if your precedents aren't that new, it might be that you do need to update them if they don't deal with excluding foreign persons. So I think it's really important that you have user notes and options in your precedent about when to include or exclude foreign persons for land tax, and also Foreign Investment Review Board issues. So yeah, FIRB approval, and also processes in there about what happens to the gift if FIRB approval is not obtained, who's paying for the expenses, that kind of thing. Digital assets and accounts is another thing. So if your precedents are a bit old, this is really a moving feast, and having powers to allow beneficiaries and administrators to deal with digital assets and accounts is really important. I actually engaged a social media law expert, Tegan Borman, to write mine because I feel like that area is so complex. A superannuation proceeds trust, the ability for the executor to set one up in the will is really important. And then just generally, I know people don't like long precedents and long trust deeds, but I do think it's important, if you've got like a 4-page testamentary trust will precedent, it may not go the distance in terms of the longevity of satisfying trust and financier requirements. And the super proceeds trust is where you want a beneficiary who should have received the super tax-free if they'd received it directly. So that's usually a surviving spouse or minor children under 25 who are dependent or just under 18. If they were going to receive that super directly from the super fund with no tax, then we want to make sure that even if they receive it through the testamentary trust, they don't pay any tax. So what you need is a sub-trust or a separate trust that only receives super, and the range of people who can benefit from that super money is limited to those death benefit dependents for tax purposes. So it's just there to make sure that there's no detriment on paying the super into the testamentary trust. And of course, we usually want super and life insurance in the testamentary trust because we want the asset protection benefits and we want those ongoing income tax benefits. So the super proceeds trust is the key to making sure that you get that same outcome. I've got much more detailed training on that if you want to dive deeper, but that was the 30-second explanation. Yeah, Craig, exactly right. Super is one of the biggest assets for a lot of younger clients. So it is really important. So I was just saying, rounding that out with like trust powers, financier powers, all of those things that you want to see in there. That's why the trust deeds do go for pages and pages. Appropriate discretionary beneficiary classes, and ability to add and remove. So it's important that you can look at this and tailor these. Are spouses included or not? What's the impact of that on family law benefits of the trust? Succession for the trustees, appointers, principals, i.e. the controllers, is really important. So making sure that whoever's nominated as the first controller can nominate their own successor on death or incapacity. And if they don't get around to doing that, there's a default in there that is appropriate who can take over. So you've always got someone appropriate to run the trust. Just general delegation powers, like ability for a trustee to nominate an attorney. The variation power is really critical, and just making sure it's broad enough. We've had a string of cases where people are doing variations to trust deeds that have turned out to be ineffective, like varying schedules or not getting consents. So being really satisfied that you're setting up these trusts with a variation power that is going to last the distance, because you can't really vary the variation power after the trust has been set up. You got to have your tax powers and definitions all right, which is a bit of a snooze, but the accountants need it in there so they can do their job once the trust is set up. Same with the income and capital distribution powers. Trustee indemnities are important so that anyone's willing to take on the job. And then also looking at your asset protection in terms of, if one of the controllers does go through a bankruptcy or a divorce or loses capacity, have we got them being removed from that process, and what is appropriate? So these trusts are intended to be multi-generational wealth accumulation vehicles. The approach that I take is it's not like the beneficiaries will just get the trust and then have it for a few years until they reach 18 or whatever. The asset protection and tax benefits mean that most people will want to run the trust for that full 80-year perpetuity period. So what we're drafting today needs to be as flexible but robust as possible to go that far. Here's a few bonus criteria. So I think if you can get precedents that integrate with your practice management system and ideally your client intake form, so you've got integrity of data, then that is just a game changer in terms of the speed of producing the documents, the accuracy, and having, a common source of truth with the names all being correct and them knowing with certainty they're correct in the documents. Letter of wishes, I think, is really important to use in conjunction with the testamentary trust, so the testator can give the trustees some guidance on how they would like them to exercise their discretion. And with my precedents, you get a training library. So how to use the precedent, both in like the procedural administrative sense, but also, like, what is a super proceeds trust and where's the clause that sets this up? And it has, like a really detailed walkthrough of what each clause is and why it's there and how that relates. So just, it's not, I think the thing with precedents is you don't want to just get a document and then that's the end of it, because you will always have questions about it, or you may not be aware of every clause. I think it's helpful. I have like a clause library of different clauses to drop in and out. So like my precedents work where there's like the main clauses that like 80% of clients would want, and then you can just drop in all the different unique tailored things. So getting a bit more support on the specific drafting. Explanation letters and information flyers about the testamentary trusts, and particularly upskilling clients on their discretionary nature, I think are really important for them to have the process so that they're understanding the trust from both your verbal explanation, but also something in writing, and also protecting you so that you've given them something in writing explaining how it all works. Ideally, if you're dealing with an estate plan that's got family trusts, that you've also got as part of your estate planning suite discretionary trust succession documents. I also think creating precedents for like meeting agendas can be really helpful those days when you need an extra cup of coffee and you just want to make sure that you haven't missed an issue. If you've got all of the typical issues there for you to basically tick which ones apply, that's going to really help you from a risk management perspective. And it really helps as well pushing like initial reviews down to junior lawyers or paralegals, because the issues are there and they just have to tick which ones apply. Same with file note templates. The testamentary trust explanations are generally very similar every time. So don't have to, even if your meeting went for longer, your file note process does not have to go longer. And then if you're looking at precedents, anything where you get Q&A support and updates, I think is really important. So this is what I think is best practice and what I offer with my precedents.